Todd.
My Lord, my ladies, my lords, my lady. Clarification is: am I making a new case? Is the point?
Yes, I think we're concerned that you're making a case which wasn't considered by the courts below, and for which you may not have been granted leave to appeal.
The points which I am making out are in answer to the findings of the Court of Appeal. I take my lords to that if I may, and also where on our grounds of leave to appeal.
Well, if you could take us particularly to where we find it in your grounds of appeal, that'd be useful.
Can I take you firstly to the statement of facts and issues? We looked at this yesterday. Yep. We looked at this yesterday because my lords will remember we had a little debate, and that was because I said to my lords and my lady, Satria's case is that the sale was effected by the heads of agreement and or the ratification of that sale and transfer. So I did raise the point full on right at the outset of yesterday's hearing.
Yes, I think hitherto had been proceeding on the basis that it was whether it was in fact ratification rather than whether Turquin's case could be relied on in order to effectively deem there to have been ratification.
Thank you. And, well, certainly, my lords and my lady, in
Could I put it this way, Ms. Todd? In order for you to rely on the rule in Turquin's case, there has to, at some stage, does there not have to have been, you have to be founding on the resolution of a board meeting without being aware of the procedural irregularities.
Correct.
Right. And at what time do you say that's to be tested?
At the time when the person who seeks to set up the irregularities, at that time.
Right.
And when is that?
I can't give you the exact date, but what I would say, well, I suppose at the latest when we issued our proceedings, the position is, or when we came to assert that we were entitled, as against the ACL, to entitlement to the shares in BEL. Excuse me if I can't remember the exact date when that was first asserted. But when we assert our right, consistently with the board resolution, and the EACL says, no, you can't rely on that, or you can't rely on the sale.
Yep.
Because the resolution approving, there was a resolution approving it, yeah, but that resolution was irregularly obtained.
Yeah. Well, if you're saying that there was some point in time, presumably between the date of a board meeting and the date when these proceedings were instituted, when the board resolution was, when you sought to rely on the board resolution as ratifying any absence of authority to enter into the HOA, would there not be an issue of fact as to whether at that point in time you were not aware of, or at any rate put on inquiry, as to potential irregularities?
I'm sorry.
We've seen how the rule in Turquin's case isn't simply a rule of, it's a rule of law, but it has to be applied in a factual context.
Yes.
And there are questions of fact as to whether or not the person relying on internal management having been carried out regularly, whether that person was in fact put on inquiry as to a possible irregularity. Is that not common ground?
I would put it a slightly different way, with respect, with the greatest respect. What I would say is this: there is a resolution adopting the contract. That's the 1st of March. Now, I understand the points which my friend has made, but there is a resolution purportedly adopting the contract. That's the 1st of March. We, as an innocent third party, are entitled to rely on that as a valid adoption of the contract.
When? Because by the 2nd of March, you knew that it was being challenged.
But on the 1st of March,
So it's the 1st of March you have to be talking.
When
you sign the transfer.
I'm sorry, my lord. With the very greatest of respect.
Well, forget about the respect.
No, I can't.
What do I say?
I shan't.
On the 2nd of March,
Yes.
you're being told that this
Yes.
is all irregular.
Yes.
So anything you rely on has to be before that.
But I am entitled to say, when they say on the 2nd of March, as a result of Turpin, on the 2nd of March, when they say that board resolution was irregular, or
Yes.
that,
You say, no, we're entitled to rely on it.
we say no, we're entitled to rely on it because we're not bound by any, or we're not affected by any irregularity in those
Well, that's a
proceedings.
very short point,
Yes.
either right or wrong.
Yes, it is.
Yes, so we don't need to take up time with it, do we? The question is whether you're entitled to raise it.
Absolutely. Sorry, that's what I was trying to. That's what I was trying to address.
Where is that? Where does one
Right.
find that
Can
in your grounds of appeal?
Can I please invite, as I was going to do, to invite my lords to bundle 6? Can I invite you to page 1761?
This is in what?
This is bundle 6.
In
This is
what?
in my grounds of appeal.
Oh, okay. Well,
This is, yes, grounds of appeal starts at page 1750, 1750, in the formal part of it, and then box, and they should be in box 6. And then we have box 5, narrative of the facts. Box 6 starts at 1760, grounds of appeal. The first one is ground 1, whether Mr. Jones and Harter had a sensible authority to make the heads.
but it's not that.
No, so I appreciate that. Ground 2 starts at 1761. Findings that P.T. Satria was put on inquiry as to Jones' lack of actual authority and Jones' failure to declare an interest in the HOA.
Yes.
Right. And then what we say, first we deal with actual authority, then put on inquiry as to Jones' failure.
Talking about the meeting of the 1st of March.
But
Can we
that
get
is-
to that?
I'm sorry?
Can we go to the meeting of the 1st of March? What
There
you're
is
saying
no-
like that?
The finding, and I can't tell my lord that there is a reference in these grounds of appeal to a meeting of the 1st of March. But it is common ground because I can take my lord to the Court of Appeal's judgment, which I was going to do in a moment.
I know they deal with it, but the question is whether you in your grounds of appeal have raised a point about the 1st of March meeting. And either you have or you haven't.
I mean, the gist of this is that you were entitled to assume that Jones and Hatter had been duly authorised to enter into the HOA and to execute it.
And, Lords, if one goes to page 1750, go.
Well, sorry, but is that not right?
I'm sorry.
My Lord Reed puts to you that you've taken us to page 1762,
Yes.
but that's all directed to due authorisation of Mr. Jones and Mr. Hatter in advance of entering into the HOA.
It's on two things, because...
Sorry, I missed what
It's
you
on 2 points, because may I take you back?
Well, if you're disputing that, if you look at B, up from the bottom of the page on 1762, it's that P.T. Satria was entitled to assume that in entering into the HOA,
Yes?
they had
Yes?
were properly and duly
Yes.
performing their duties.
And indeed, if one goes back to 1758, if I may invite my Lord's attention, issues before the Court of Appeal and treatment of those issues at 1758.
Yeah.
And we see in the second paragraph there whether EACL's board ratified the share transfer agreement on the 1st of March 2015.
Yep.
The Court of Appeal determined that that meeting was validly summoned, but since Harter and Jones had an interest, which they failed to disclose, the meeting was in quorum without effect, as such that the resolution of the board purporting to ratify the transfer had no effect. And then we saw this just yesterday, I think, 1759, at the first full paragraph where the HOA was avoidable and avoided by EACL. And then we looked at issues in the appeal to the Privy Council. At the bottom of the page, we looked at that yesterday. And then we find ground 2, which I've been referring to, and my Lord has taken me back to, at page 1762, put on inquiry as to Jono's failure to declare an interest in the HOA. In the context, as a whole, of the Court of Appeal's judgment, that is the relevance of the declaration of interest so far as the Court of Appeal was concerned, which is the judgment under appeal, was in relation to that meeting of the 1st of March.
Yeah.
And I can show my Lords that, if you allow me to take you to it. And then we set out what the court ought to have concluded by reason of the ruling in Tokens case. And
can I ask, was this case put at first instance?
may I just put it? Lord,
My next question was going to be, was it put to the Court of Appeal? Because at the moment, I don't think it was put at either first instance or in the Court of Appeal.
Lord, may I firstly take you to the Court of Appeal judgment and work backwards?
All right.
Would you bear with me to...
Certainly, yes, sorry, whichever you find.
I don't want you to leave the grounds of appeal until you have
sorry, which
well, you can take from me that, first of all, while we have the grounds of appeal in front of us, we are still looking for anywhere in the grounds of appeal where this point is focused.
Where this point is
focused.
Is focused. Where we put it on is in relation to page 1762 under ground 2.
Right.
And at 1763, the court relied on the fact, if one picks this up at the, we deal there, that's all conflict of interest and indication of being no declaration of interest. And then at ground 3 at page 1765, findings as to the right of the ACL to avoid the HOA, the court erred in finding that the HOA was avoidable. Now, my Lord, that was comprehended within our grounds of appeal is plain as a pikestaff in my respectful submission from my friend's written case, if for no other reason, and I will come back. I will come back to the Court of Appeal.
We're more interested in finding it, if we've exhausted the grounds of appeal, in seeing how it's raised in your written case.
Thank you. Well, Lord, in our case...
you do specifically say in subparagraph C under ground 1 that Satria was not bound to inquire whether internal requirements of EACL, including any obligation on Jonos to disclose an interest in the HOA, had been satisfied, and the internal requirement was on the case as put the requirement to disclose at the meeting of the board on the 1st of March.
Lord, my lady, your Lordship's absolutely right. As I was trying to take my Lords to the Court of Appeal judgment, that is what Justice of Appeal Clark was specifically addressing.
Sorry.
Well, anyway, so those are the grounds of appeal. And then does my Lord Kitchen wish to...
No, I just want to be clear, you've finished with the grounds of appeal.
I have finished at the moment on the grounds of appeal. One sees, of course, on page 17, one sees, of course, at page 1763. What we say is the court relied on the fact there was no indication there had been any declaration of interest when the HOA was made at the board meeting on the 1st of March 2015, or by notice to all directors. My Lord sees that, and my Lady sees that. However, the absence of such an indication was insufficient to put PT on inquiry, given that, and we say, for example, that PT Satria saw, there's no evidence PT Satria saw any documentation, no evidence that PT Satria ever saw the minutes. Further, a declaration of interest by Mr. Jones or Mr. Harter would not necessarily have been contained in or disclosed by minutes made at the time of the HOA. A declaration of interest could have been a general historic declaration made by them at an earlier date, particularly having regard to their conduct of negotiations for a possible investment in or sale of BEL on behalf of EACL over many years. To discover such a declaration of interest would have required an inquiry through EACL's historic board minutes, which is the type of roving inquiry which a third party is not required to undertake by virtue of the indoor management rule in Turquoine's case.
Yes.
There is no suggestion we saw any documentation which might have been expected to contain or record a declaration of interest by journos and so on. The conclusion that in the absence of documentation indicating the declaration of interest had been made ought to have put PT Satria on inquiry. Such declaration has not been made does not follow, and there's no factual basis for that Court of Appeal's conclusion. So that's the way it was put, and if I may respectfully say so, I would suggest that adequately... That's
if that's your case, then we know what it is.
Thank you.
Well, I mean, why are we taking so long?
Because I'm being asked a lot of questions, my Lord.
I mean, I asked you to identify your case, and you say that's it. Well, let's get on with it.
Thank you. I'm sorry I didn't deal with the clarity that you were expecting. Now, is it... my friend, Mr. Howard, says it's not my case.
No, but if he knows what your case is, I'm quite sure he can deal with it. His problem, I suspect, is he didn't know what it was.
Well, actually, if you would just bear with me for 2 more minutes, and I will... Could I invite your attention, please, my lords and my lady, to page 1898 of Bundle 6. This is my friend's written case. The consequences of the failure by Mr. Jonas and it's paragraph 45.
Thank you.
The consequences of the failure by Mr. Jonas and Mr. Hart. And this is in the context of declaration of interest. You see that from 44. To make proper and timely disclosure of their financial interests in the HOA were that Jonas and Hart were both disqualified from voting at the board meetings, etc. And 2, the purported ratification of the HOA and the approval of the transfer of the shares in BEL were both invalid and without legal effect. It was clear in our respectful submission from the grounds of appeal. We made it clear in our case, and the other side understood it.
I'm sorry, which page was that?
That is page 1898, my lady.
Oh, thank you.
And that is my friend's written case, in answer to our written case.
At paragraph?
At paragraph 45, my lady.
Thank you.
To suggest they didn't understand the case being made, I'm afraid, is surprising.
There's a reference there to roll steel and to being put on
Absolutely.
inquiry.
But isn't that their response to a distinct case that you are running on ratification, namely internal ratification, because this is giving reasons why internal ratification didn't work?
Our case, we said that as you saw from the grounds of appeal, my lord, the case we said is you're not entitled, we're not required to make the inquiries, we can rely on Turquoine. That's in the grounds of appeal, which I've taken my lords and my lady to.
I see.
Have I... If it's clear that it was open to me, may I sit down? If you, I would have wished to go through some more, but I know Lord Carnwath is keen to get on.
Sorry, I don't want to show signs of impatience. We're on the second day of a hearing, which we've got to finish by 4 o'clock. And if what you're saying is your case in those paragraphs, and that's the response to it, then we can deal with it.
Yeah. Mr. Howard?
My Lord, it is very unfortunate the way this is arising, and I do need to, I'm afraid, just show you a bit more about what has happened. Firstly, you were taken to the issues on appeal, and you have to remember what we're talking about is, have they appealed the Court of Appeal's finding that there was not ratification. Now, if you look at page 1759 and the issues on appeal, I ask rhetorically, which of those issues is saying, bear in mind what was on the previous page, page 1758, where they had as their second finding whether the EACL's board ratified. Then you go to the issues in appeal to the Privy Council and the issues raised. You will not find ratification raised as an issue. That is self-evident, and for Mr. Todd to say that is part of his case is simply wrong. And what is more, if you look at Mr. Todd's written case, he said, I've dealt with it in my written case. And so what you'd expect to find in the written case is applying the rule in Turkland to the 1st of March. Well, let's actually have a look what he did do in the written case. I'd invite you to go to paragraph 58 and 59. I beg your pardon? He wants to go to 44 to 47. 44, one can see, is about criterion and being put on inquiry about their authority. 49...
44 is to do with, the last few words indicate it's to do with authority to conclude the HOA.
Exactly. And then... now, this is all, got to remember, this is all in the context of the heading is whether Satria was put on inquiry as to Jones' lack of actual authority and the failure to disclose his interest in the HOA.
Both matters, Mr. Howard.
Oh, yes.
Both matters, and the only issue is whether it should have been disclosed at the meeting.
No, that's...
Well, that's one of the issues. It was certainly an important part of the issues that it should have been disclosed on the 1st of March at the board meeting.
Milady, but, with respect, the issue of law that is sought to now be raised, that's good to remember, what we're talking about, is what is sought to be run as an argument now, is that you can apply the rule in Turkland in relation to the board resolution. That's the question we're debating as to whether that has been part of their case at any stage, that somehow...
But I mean, don't you have an easy answer saying that's wrong?
It is wrong.
I mean, why are you fussing so much about the point being raised if you can deal with it?
I can deal with it because it's fundamentally wrong.
Yes.
But one of the things, so I'm happy in a way, but I think it is important to just understand that this isn't a point that's ever been argued in this case.
Well, obviously, if it raises factual issues...
Yeah, well, it depends what it... The problem is that one has to know what the factual premise is of it. And different things have been floated at different times in the submission. If the only premise is this, there was a purported board meeting on the 1st of March, and which they never saw the minute of, and they want to say, well, I can rely on the rule in Turkland to say that an invalid board meeting is valid. Yeah. That's obvious rubbish, but I'm happy to address it. If, though, on the other hand, what they're seeking to say is, well, we saw this at some stage, and we...
They're not saying that.
Well...
I understand it. I mean, they can't say that.
Well, they can't say that, but if then what you're talking about is a board minute which at no relevant time has been seen by...
Not a board minute, a resolution. I'm sorry, it's not the same thing.
The board... it's a resolution of the board at the board meeting, which has never been seen or relied on by PT Satria.
Well, could you just go, I'm sorry, it's just very important that we conclude this in the minimum time. At paragraph 58 of the written case, at 1866.
That's what I was going to go to, yeah.
If there was a conflict of interest which was not disclosed by Messrs. Janos and Hydra, Satria could rely on the indoor management rule in Turkland's case.
Yeah. And one needs to read on to see what the consequence is at 59. Yes. And the consequence is entirely, this is actually a very important paragraph. They say, Clark seems incorrectly to have concluded that Satria relied on the rule in Turkland to establish the creation of ostensible authority. i.e. that Satria claimed to be entitled to rely on the rule in Turquin to assume that Jones and Hatter were authorised. However, the ostensible authority arose out of their long-term dealings, etc. By causing, permitting or acquiescing in Jones and Hatter acting on its behalf, they were held out as authorised. The rule in Turquin's case is relevant because EACL seeks to deny the ostensible authority by asserting that reliance on the ostensible authority is precluded by their failure to declare a conflict of interest. However, the alleged non-compliance in respect of matters of internal management, accordingly, Satria is not concerned with them, owing to the rule in Turquin's case, and Jones and Hatter's ostensible authority is not undermined. In other words, it's entirely a case by reference to ostensible authority. And what they are saying is, there was ostensible authority, you held them out as having authority. The fact that they didn't disclose at any stage their conflict is not something I need to be concerned about because you had held them out.
It's the same point, Mr. Howard. If the declaration of interest was to take place at the board meeting, this is about the failure to disclose at the board meeting, and that applies to both C and D.
Well, I don't accept that's right.
Well, it was a material time when it should have been disclosed, and your case is that it wasn't disclosed.
I beg your pardon?
And the Court of Appeal found that it hadn't been disclosed.
It hadn't been disclosed at any time.
Yes, I know, but the statutory requirement, because there's also reference to Section 97 in the grounds of appeal.
But with respect, there are one's confusing different points. The first question is whether the HOA was a valid agreement. Now, part of the reason it wasn't valid, well, there are two things. The HOA wasn't valid because there was no authority. But if there was authority, then it was voidable because they had the conflict of interest. And the Court of Appeal held that it could have been avoided and had been avoided if that was necessary. But with respect, my lady, the point that is being made at paragraph 59 is not that Turquin's case can be relied on to create a ratification.
The word ratification doesn't come into this analysis at all. It's simply a question whether or not, if you have a board resolution, and it is said that it is irregular because of a failure to declare an interest, and that was so found, we're not concerned with the short notice or anything like that, then the question is whether or not the third party dealing with the company is bound by the irregularity. Now, there may be lots of answers, but I'm sorry if you think I'm confused, but C and D seem to me to incorporate that matter.
Well, I would
speaking entirely
suggest
for myself.
that they do not. That they are simply concerned with the question of ostensible authority. And that's actually what it says in terms.
You know, that insofar as that's the point, you're able to answer it, and you accept that it's on the... I mean, at the moment, we're just worrying about what you're supposed to be answering.
Well,
there you've got the point, and we've got it.
I'm...
You know, you're in a difficulty, because you're having sort of points put at you in all sorts of slightly different ways.
Yeah.
But my understanding is that Mr. Todd has identified from his grounds of appeal the points that he thinks he's arguing. My lady has identified the point that she had wanted to put to you, and you've dealt with those, and we can move along.
Well, I mean, I don't want to keep saying that this is an unsatisfactory way of dealing with things, but I respectfully say it is when I'm in reply, and we all seem to be somewhat unclear as to exactly what the case is. And what in my submission is clear beyond any doubt is that, and this is a point I was making yesterday, the other side have not raised as part of their grounds of appeal an issue that the Court of Appeal should have found that the board meeting on the 1st of March constituted a ratification. And it seems to me that it should be the beginning and end of it. If that isn't part of the grounds of appeal, this point falls away.
That isn't contended. The whole point is that it was an irregular resolution, so it wasn't a ratification.
Well, I think
So
it
that's
is
the premise of the argument.
No,
So
my lady,
wouldn't...
I'm sorry to interrupt, but it is contended. That's exactly what Mr. Todd is now
No,
arguing.
he's saying by virtue of the rule in Turquin's case, you got precluded from asserting it was not valid ratification.
No, but therefore it is being asserted that the... Sorry, I'm not sure what it is I'm misunderstanding, but the question of the 1st of March board meeting, with respect, is only relevant once one has determined there wasn't ostensible authority. And so the other side rely on the 1st of March meeting. That's what they were doing at the earlier below, to say that constituted a ratification by the company. So the question, and the Court of Appeal held it wasn't a ratification. So if the other side wished to now argue that it is a ratification, in other words, they've lost on ostensible authority and they want to say, I get out of jail by reference to ratification on the 1st of March, then that would have to be part of their grounds of appeal.
But if they're arguing on Turquin's case, all they have to say is it was an apparent resolution. They don't have to go into the question whether it was or was not.
But they still have to say that the Court of Appeal should have found that by virtue of the board meeting of the 1st of March, the company is to be treated as bound by it, and therefore that constitutes an act of ratification. That's what they would have to be part of their argument.
I don't think it puts it into the field of ratification. All it means is that this particular third party, that's their case, they're only concerned with themselves, can rely on it. It doesn't put it into the status of a valid ratification for all purposes.
But I'm not sure that I understand what it is.
Well, there could be other parties who are affected. There could be other parties. There could be a question of the liability of directors and all sorts of things if it were a valid ratification. But all they're saying is it's apparent.
But my lady, accepting the point that this is just a question of ratification as against PT Satria, it would still, I'm just looking at it as part of the case that's in front of you. The case that is in front of you in our submission is simply that the Court of Appeal were wrong to find that Jones didn't have ostensible authority. A further ground that they could have run but they haven't was that the Court of Appeal was wrong to find that there wasn't a ratification, at least as against us. And you won't find the ratification in the grounds of appeal. That's the beginning.
I would only be repeating myself, Mr. Howard, if I responded.
Yeah. I don't want to take up time unnecessarily, but I think there are concerns about this, which we ought to sort out amongst ourselves. We'll adjourn for a few minutes. Well, our discussion of whether or not this argument should be admitted is liable to take some time, and we are conscious that we don't have a great deal of time. So what we would propose to do is hear what you have to say in response to the argument, Mr. Howard, de bene esse, and we're reserving our position as to whether we will, at the end of the day, entertain the argument at all.
What one needs to, if I can just remind you where we are in the discussion, we have dealt with ostensible authority, and the meeting of the 1st of March becomes of relevance if we're right on ostensible authority. And then the question is, and that's why it's relied on, is as an act of ratification by the company. Now, as I understand it, therefore, the argument that is now sought to be run is that because there is a purported meeting on the 1st of March, notwithstanding the fact that at no relevant time does PT Satria know about it, they can nevertheless now, or for the purposes of the litigation, rely on it. Of course, the facts are, as my Lord Carnworth pointed out, that on the very next day, the 2nd of March, which is in Bundle 5 at page 1642, Mr. Suhardno was informed that they're not aware of any board meeting. He's informed, and the second sentence, it's come to our attention that on the 1st of March, Hatter and Jones improperly sought to transfer the shares of Bell owned by EACL to your company pursuant to the enclosed copy of a share transfer form signed by you on behalf of PT Satria. Please note that this is not a valid or effective transfer of the shares, and therefore no transfer of shares has occurred. And that point was reiterated at page 1658 on the 6th of March when they were told that Jones and Hatter had been removed. Now, if one just pauses for a moment to think about this, the position would be fairly astonishing. You have a contract which is purportedly signed on the 27th of February, which the court will have found that was not an authorised contract. You then have a board meeting which takes place improperly in the sense that the conflicts are not disclosed and so on, and of which PT Satria know nothing. And then PT Satria are told on the 2nd of March, the day after the board meeting of which they don't know, that the share transfers are completely invalid. Now, if one just pauses for a moment, it would be a pretty odd position that English law was such that in that situation the company was somehow to be treated as bound. Now, that is, in our submission, that is actually why this point has not been raised below, both in first instance in the Court of Appeal, nor does it feature in the grounds of appeal, nor in the written case, because it is simply plainly and obviously wrong. The position is, as I think was discussed yesterday, the question of whether there was ratification this is not a situation where there's been any communication to PT Satria. So it's not that PT Satria is entitled to rely on anything that it has seen. I think when Mr. Todd just before lunch introduced this, he said an innocent third party is entitled to infer that a resolution has been passed. But of course that's not the law at all. I mean, where you have a contract here passed, entered into without authority, you're not entitled to infer that the board has subsequently approved it. That's entirely contrary to the various decisions that we've already looked at.
You say the first time Satria heard about it, they were also told, effectively at the same moment in time, that the resolution was invalid.
Before they know about it.
Before they even know about it.
Before they know about it, they've been told that the purported share transfer is completely invalid. Then they're told these people have been removed. And there's no evidence as to when they do learn of the board board minute. The first time, I think, the only thing you can say is it's referred to in Mr. Suhardno's evidence that I showed you. But in that situation, in our submission, it's just impossible to see where the rule in Turkwind how it fits in. It's all about, it's about protecting an outsider who is dealing with a company who sees something from some outward manifestation from the company of something that has been done. For instance, the company has, for instance here, if you produce a board minute or a resolution, that's an outward manifestation. Now, it may well be that the internal management rule required certain things to be done to make that valid. But what Turkwind is all about is where you're entitled to not look behind this. But what it doesn't do is allow you to say, well, there's things I didn't even know about, but I see this person purported to do something, and I'm entitled now to come along and say, well, somehow I can take advantage of that. Now,
I wonder whether it goes back to what my Lord Reid put to Mr. Todd. Do you even need the information about the meeting? Because if the argument is followed through to its logical extension, it's just, well, companies can ratify contracts which are entered into without authority, so why not assume that it has?
Well, I think that's where he started his submission today. He started to say, well, you can entitled to infer that there has been a ratification, because that's just saying
you don't need to know whether, in fact, there was a meeting or there wasn't, because if you're relying on Turkwind's rule, the innocent third party just assumes.
On Mr. Todd's approach, it's just completely irrelevant whether you've seen this or not. And indeed, it's irrelevant whether any meeting has taken place or not. In a way, it's a sort of submission that's quite difficult to deal with, because it's really so far off anything that is that one is familiar with, frankly. If this were a serious point, one would have expected Mr. Todd, with all his learning in company law, to have produced authorities that relate to this, whereas all he's saying is, look at Turkwind, and perhaps we should just look at that, because he says this is Turkwind sort of provides the answer, but it's in volume 7, tab 2, 1943. Part of the problem with this is if you, just before we look at that, you go to the Court of Appeal, and part of the reason one hasn't come along armed with a lot of learning on this is because this wasn't a point that appeared to be an issue. If you remind yourself of the summary of Turkwind's rule at paragraph 102 of the Court of Appeal, the rule in Turkwind is actually it's not a particularly complicated rule. You see from Halsbury, persons contracting with a company and dealing in good faith may assume that acts within its constitution and powers have been properly and duly performed, are not bound to inquire whether acts of internal management have been regular. And as Lord Justice Clark notes in the next paragraph, the rule, whilst covering procedural irregularities, such as a failure to have a loan passed by the relevant board committee, does not extend, as we saw before, to automatically assume a delegation to a director. But all of it assumes that you are some outward manifestation is presented to you, and then you're entitled to assume that has been properly observed. And if you go to Turkwind, the issue, if one looks on page 1943, if you look at the facts in the right-hand close type, plaintiff declared against defendants a joint stock company on a bond signed by two directors under the seal of the company, whereby the company acknowledged themselves to be bound to the plaintiff in £2,000. The plea set out the condition which appeared to be for securing to the plaintiff, who was a banker, such sum as the company should, to the amount of £1,000 owe on the balance of the account current from time to time, and for indemnifying plaintiff to that amount from losses incurred by reason of the account between the plaintiff and the defendants. Plea further set out clauses of the registered deed of settlement by which it appeared the directors were authorised under certain circumstances to give bills, notes, bonds or mortgages, and one clause provided the directors might borrow on bond such sums as should from time to time by a general resolution of the company be authorised to be borrowed. The plea averred that there had been no such resolution authorising the making of the bond, and it was without authority. And then the replication set out the deed of settlement by which it appeared the company was formed for the purpose of carrying on mining operations. On demurrer to the plea and replication held by the Court of Exchequer, the plaintiff was entitled to judgment, the obligee having on the facts alleged a right to presume there had been a resolution at a general meeting authorising the borrowing. Chief Justice Jervis, such resolution would confer sufficient authority if it authorised the borrowing on bond on such sums as directors might deem expedient in accordance with statute and deed without otherwise defining the amount. And at page 332 of the judgment, 1948, is the judgment where he explains in the second line, the deed allows the directors to borrow on bond such sums as shall from time to time, by a resolution passed at a general meeting, be authorised to be borrowed. The replication shows a resolution passed at a general meeting authorising them to borrow on bond such sums and at such rates as they might deem expedient, in accordance with the deed of settlement and the Act of Parliament. But the resolution does not otherwise define the amount to be borrowed. That seems to me to be enough. And then further down, he says, we may take for granted dealings with these companies are not like dealings with other partnerships. Parties dealing with them are bound to read the statute and the deed of settlement. They're not bound to do more. Party here on reading the deed of settlement would find not a prohibition from borrowing, but a permission to do so on certain conditions. Finding that the authority might be made complete by a resolution, he would have a right to infer the fact of a resolution authorising that which on the face of the document appeared to be legitimately done. Now, that, and obviously there's then been a lot of subsequent learning as to how the rule applies, but in my submission, I'm not aware of any authority where anyone has sought to rely on something being done by a company of which they are completely unaware, where here the company has subsequently repudiated the step, but they are saying, well, the guillotine came down and indoor management is irrelevant, and so I can say, because these directors purported to hold a meeting, you're bound by that as being an act of ratification.
I mean, you say this is absolutely far from a normal application of Turkin's case. One can see at least the argument in the case of the heads of agreement. But when it comes to the resolution, as soon as they know about the resolution, or indeed before they know about the resolution, they know effectively that it's challenged.
Yes.
That these people are rogue directors. And so the application of the principle articulated by Lord Justice Atkin in Houghton and by the Privy Council in Akai, both of which are referred to in the Court of Appeal's judgment, first at 103 and the second at 105, make it clear that Turkin's principle simply doesn't apply.
Yeah, but that's really,
Yeah.
that's actually the long and short of it. It's got absolutely nothing to do, and that's what I said yesterday, and I really repeat, that we're simply concerned with whether the company did in fact ratify. That is whether there was in fact a valid board meeting, and that's got, you can't, as it were, sidestep that by saying it should be deemed to be valid.
Yeah, I mean, it wouldn't just tell them whether there's a valid board meeting, it's also whether the resolution is valid.
Yes, yes.
And you say the resolution isn't valid because
Exactly.
any directors who voted on it had personal interests, not declared to the company generally
Exactly.
or to the other director.
Yeah, exactly.
And what about inducement to enter into the transfer? There was, could it be said that there is no evidence that the transferee was induced to enter into the document, the instrument of transfer, in the knowledge that there was a board resolution?
No, there isn't.
That's another requirement.
There is no, the share transfer document was executed before the board meeting, And there is no evidence. The evidence is the opposite way. Mr. Sudano didn't know about the board meeting.
Yes, this is a point I raised yesterday about the interval between the 27th.
Yeah, this isn't a case where what was being said was, well, they told me they'd held a board meeting and they produced the resolution, and on the basis of that we all signed up to this agreement or something like that. That might be a different case, but that isn't this case. And so we are in a very odd situation where somebody is saying, because, I mean, for the purpose of this argument, it could be years after the event that you find out, even though the whole thing's been repudiated, you find out that there was this purported board meeting, and you say, aha, that constituted an act of ratification, even though, in fact, the company has subsequently repudiated it, and you haven't taken any steps in reliance on it. I mean, I'm struggling to deal with the point because I just can't see how it fits into any sort of legal analysis that makes any sense, frankly.
Insofar as any evidence might be relevant, it doesn't seem to have been the subject of any evidence given by Mr. Sordano.
No. Well, I mean, I think the evidence is that he didn't know about any of this.
Yeah. Yes.
Indeed, it would be one of the things. It's one of the reasons. It's pretty clear he couldn't have known about it. Is, you remember, the HOA is predicated. It says that they have got approval. So it would be a bit odd for them to say we're actually going to hold a board meeting to get approval. That would give the game away. So the other point that I would make, which is why it's sort of completely counterintuitive, the suggestion that's being raised. As we've seen, it's common ground on the authorities that one of the things that arises is you can't rely on the rule in Turquin's case if you're put on inquiry. Now, how can you be put on inquiry when you don't even know what it is that's supposed to have been done?
Well, you're put on inquiry before you even know it's been.
Yeah, well, exactly. But on Mr. Todd's case, he says, no, because all you have to look at is what happened on the 1st of March. Because I'm ignorant about what happened on the 1st of March. The fact that you tell me on the 2nd of March and the 6th of March this was all invalid doesn't matter, because the guillotine came down on the 1st of March. And I wasn't put on inquiry because I didn't know about it. I mean, it's almost like a parallel universe, this. But I mean, I don't want to be rude, but I do find it difficult to really see how any of this can sensibly arise.
In Turquin's case, there was this delivery of a bond, and that's rather like the point made by Lord Neuberger, isn't it, in Akai, that in some circumstances the court would be quite confident that there had been reliance if there had been some document, I think it was a charter party or something. And here there was a bond, which was a representation that the bank was authorised to pay on it.
Yes, exactly.
Which we don't have an equivalent piece of writing in this case.
Again, if giving a sort of hypothetical, assume the board minutes and the resolution had been sent to Mr. Sudano, and he had then, his evidence was, I saw that, and I relied on it, and I then paid over the $1.9 million, we might be in a different scenario, because he would then be saying, there was a representation by the company, I'm entitled, he would say, to rely on the rule in Turquin, and so on. I'm not saying it's right, but it's a different case, but it would at least be closer to what we all understand the rule in Turquin is about. But where you don't know anything about it, in our submission, it's completely impossible. The other point, I see the time, is this, that in any event, we submit, and the Court of Appeal has found, that PT Satria was put on inquiry, because they dealt with that in the context of avoidance, because that is actually where all of this argument in the written cases has been focused, as to whether or not my client, if there was a valid contract, was entitled to avoid. But exactly the same facts for put on inquiry for avoidance would be relevant as to why you can't rely on the rule in Turquin. But I mean, it's an a fortiori point for the rule in Turquin, because before you in any way rely on this anything to do with the board minute, you're fully aware of the fact that the company has repudiated this. But in terms of why they were put on inquiry, we rely on the points that were made by the Court of Appeal at paragraph 132 and paragraph 140, essentially you come back to, and we've seen all the cases which deal with put on inquiry in the context of Turquins, you have a situation where EACL is purporting to dispose of its only asset on terms where it isn't actually getting paid anything, at least in any real sense, because its any money is long into the future, if at all, where Jones and Hatter have a patent conflict of interest, and anybody dealing with Jones and Hatter in that situation would be put on inquiry as to whether this has been properly considered. But what is odd is, that's why it's quite difficult, well, if you're looking at it just as an avoidance case, it makes sense because you're asking whether the HOA should be avoided. If you're looking at it by reference to the board meeting of the 1st of March, since they don't know about it, they couldn't be put on inquiry as to whether the board meeting was properly conducted. But if you somehow treat them as having to know about it, then you'd have to say, well, they were put on inquiry. So, I think I've largely made my submissions. I don't know if there's anything else on which I could assist you.
No, I don't think so, Mr. Howard.
Okay.
Thank you very much. Mr. Lawson. Thank you. Mr. Todd.
Grateful, my lords, my lady. Firstly, if I may just deal with, because it assumes some importance in this case, I would suggest. Some people think it hasn't got very much importance, but I think it's of some importance. This notion of what happened, or the effect of what happened at the board meeting in relation to the transfer. I put it in that neutral way. The fact that there was actually a valid board meeting, although I don't think it really matters for the purpose of this argument, is clear from the Court of Appeal's judgment at paragraphs 85 and 86. The failure to declare an interest did not mean that the meeting was inquorate. All it meant, so that's page 74 of volume 1. It's a question of whether or not Mr. Jones and Mr. Harton were entitled to vote on the relevant resolution. So there was, the Court of Appeal has found, accepted, there was a valid board meeting on the 1st of March. I'm not suggesting for one moment, please don't think I am, and I sincerely hope Mr. Howard doesn't think I am, suggesting that Mr. Suadano or P.T. Satria knew of the board meeting.
But, I mean, the board meeting could be validly convened, but when everyone turns up, because of the circumstances in which they're seeking to act, it is in fact inquorate. Is that not possible?
That is possible, but there is nothing in the Act or in the bylaws which says that the meeting is invalidly convened. What they're disqualified from doing is voting on the business in which they are interested.
Surely it's implicit in quorum that you're counting people entitled to vote.
That's absolutely, my lady. That's absolutely what I'm saying to my lady is this: that when it came to the resolution to approve the HOA and the transfer, then it was inquorate because they couldn't vote. So my lady's right. The only sole point I'm trying to make is to say that, as at the 1st of March, there was a valid board meeting. It had been validly convened.
I think that's
whether or not it could
common ground now, isn't it? Because the basis was not basis of the original ground for saying it was not validly convened. The letter by Mr. Yamura has not been raised as a ground here. But it had to be a cross appeal.
So, my lady. But anyway, let's leave that to one side. But if I look at Turquoise, we have looked at Turquoise very briefly. It is an important case. I mean, people say the rule in circles is the indoor management principle. They describe it in various different ways. In my respectful submission, the way it was described in... Have you got the Hallsbury bit? We've had a look at Turquand, and if I could invite my lords and my lady to page bundle 7, tab 2, page 1948. And what I tried to say to my lords and my lady before lunch, or tried to address you on this point, is what is clear is there was actually no resolution at all to make that particular borrowing. And that's clear. Just picking it up at the top of the page, if I may. The deed allows the directors to borrow on bonds such sum or sums of money as shall from time to time by resolution passed at a general meeting of the company be authorised to be borrowed. A replication shows a resolution passed at a general meeting authorising the directors to borrow on bonds such sum for such periods and at such rates as they may deem expedient in accordance with the deed of settlement. But the resolution does not otherwise define the amount to be borrowed. That seems to me enough. So there was no decision by the board, no resolution of the board determining the amount that they wanted to borrow. There was
but there was a positive resolution that they could borrow.
There was capacity to do so, that's right, if they decided amongst themselves to borrow. Your Lordship's absolutely right. But because, I'm going to, if I may, if you please bear with me, he then goes on to say, Chief Justice Jarvis goes on to say, if that be so, the other question doesn't arise. But whether it be so or not, we need not decide. For it seems to us, the plea, whether we consider it as a confession of avoidance, etc., we may now take for granted that the dealings with these companies are not like dealings with partnerships, and the parties dealing with them are bound to read the statute and the deed of settlement, i.e., do you have capacity to do it? And that's the point my Lord Sales has just put to me. But they're not bound to do, they're not bound to do more. So you just find out, have they got capacity to do it? This is the real rule in Turquand's case. And the party here, on reading the deed of settlement, would find not a prohibition from borrowing, but a permission to do so on certain conditions. That's what you've got here in the article, the Amendment Arts. Then it follows. Finding that the authority might be made complete by a resolution, i.e. contemplating that a further resolution is needed, I suggest that means, he would have a right to infer, the third party would have a right to infer the fact of a resolution authorising that which on the face of the document appears to be legitimately done. So it contemplated, the court was contemplating that a further resolution was required, determining the amount to be borrowed. And what Chief Justice Jarvis was saying is when you know you've got capacity to borrow and you know that it can be actually specifically authorised by a resolution, you don't have to ask, has there been a resolution and can I see it? That is the rule in Turquand's case. And that's the indoor management principle. And the way it is, my lords have seen, going back, if I may, to the Court of Appeal, a judgment at Bundle 1, page 81. My friend has just taken you to this, where in Morrison Canson, paragraph 102, Lord Simmons says in Morrison Canson, the so-called rule in Turquand's case is, I think, correctly stated in Hallsbury's laws. But persons contracting with a company and dealing in good faith may assume that acts within its constitution, i.e. within its and powers, i.e. within its capacity, have been properly and duly performed and are not bound to inquire whether acts of internal management have been regular. So there's nothing, and that is what Lord Simmons says in Morrison Canson is the effect of what he's accepting what is said in Hallsbury. You see whether something is within the constitution and powers of the company, and when you reach that, when you reach that conclusion that it is, then you're not bound as a third party dealing with the company to inquire further whether or not there's actually a resolution. to authorise the specific act which you're seeking to rely on. That is Turquand, that is Morrison-Canson, that's Halsey, and that is Morrison-Canson. So, and what my lady, Lady Arden said to Mr. Howard, but of course, what my lady said to Ms. Howard was, of course, there was a manifestation in that case. In Turquand, that is a bond. So a manifestation to the third party. And in our respectful submission, there was, in this case, a manifestation, not that a resolution had actually been passed, but a share transfer was handed over, was signed by both EACL and by PT Satria and is dated the very same day as the board resolution of the 1st of March 2015. Now, in our respectful submission, the directors had power to sell the assets. That's within the constitution of the company. We've been through that before. And I say Houghton is nothing to the point. I say, look at the constitution. We went through that in a little detail yesterday morning. The board can act by 2 out of 3 directors and so on. And I took my lords to that and my lady to that. And so the board can exercise all of the powers which aren't reserved to the shareholders. And I took my lords and my lady to that. The sale of these assets, or this sole asset which it had, was not a matter which was reserved to the shareholders of EACL. The board, therefore, had the power to execute this sale. And based on Turquand, knowing that that was within the constitution of EACL, and as Lord Simmons accepts, they need do no more. They've been given a transfer. They needn't ask anything more than that. Here's a transfer which I've been given for all the shares in BEL. I don't have to make any inquiry. I can assume that that has all been validly authorised by EACL. That is the effect of Turquand. That is the effect of Morrison-Canson.
As it seems to me, if that argument were right, it would apply to the heads of agreement, but that would be contrary to all the authorities we've seen, that you can't rely on Turquand's rule to give yourself ostensible authority.
Lord, what I'm meeting here is what I have. That there is a transaction which has been entered into. A transfer has been handed over. And what I'm meeting here is that the principal, on whose behalf the agent has handed over the transfer, has done so without authority. It hasn't been regularly authorised within...
Well, that's why I put to you what I did, because the heads of agreement has been handed over likewise.
Absolutely. But what I'm not relying on that. I'm not saying that Turquand goes to that. What I'm saying is a matter of indoor management, the transfer having been handed over, it being within the constitutional powers of the directors, then the third party need do no more.
And you have 2 further difficulties, it may be said. First of all, you did nothing in reliance on the resolution. You simply accepted the share transfer. And second, when you became aware of the resolution, you already knew that the validity of that resolution was under challenge.
I think on there you're effectively saying that the resolution is irrelevant to this argument.
I can infer it's been done.
Yeah.
Turquand.
Well, yes, you're not relying on actual resolution, you're relying on something inferred which may have been before the heads of agreement, may have been any time. So one then comes back to all the other arguments about whether you can infer authority and whether you should have been put on notice and all that.
Absolutely.
But the actual resolution of the 1st of March seems to have disappeared from the case.
I don't actually have to say there's a resolution and I can rely on it. I don't need, strictly on Turquand, I don't need to do that.
It makes it much easier if we can forget about the resolution,
Yeah,
which we've been spent an awful lot of time fussing about.
I mean, but the, you know, the fact of the matter, the fact of the matter is, what we say, and the alternative way I put it, and my Lord Sales put this to me I said I submitted that, of course, ratification. Take my Lord Sales' way of looking at it. The ratification. I submitted that it didn't need to be communicated. And in a sense, in relation to the ratification, that is the resolution. This is the alternative way. In relation to the ratification resolution, then again, in relation to, if I have to rely on that resolution, I say I don't have to rely on any I'm not bound by any irregularity which may affect the passing of that resolution. So, my Lords and Ladies, that is what I say. So, the manifestation, as I say, took place on the 1st of March. So, in relation to my Lord Kitchen's second objection, additional objection to the transfer, which is that as soon as you knew of the resolution, you knew it had been repudiated. But of course, Mr. Howard has been telling my Lords, I can't say I know myself, been telling my Lords that and I'm not doubting this, that the transfer was before. The transfer that was signed before, and it was signed by P.T. Satria. Mr. Colombo is of P.T. Satria, before the resolution. So there's a manifestation. Here's the transfer to you. There's a manifestation that this transfer has been effected. So I say that simply, my Lord Kitchen, in relation to your second point, that.
Sorry, I'm not sure I picked that up. So you're saying that the share transfer form was signed before the board meeting and the resolution?
I'm saying that Mr. Howard has told this court that.
I wasn't conscious that he had. All right.
Because he had.
I said that as a matter of logic, because the purported resolution is approving a document that has already been signed.
I see. All right. Sorry. Thank you. My fault.
Yeah.
So
we don't have any evidence about that, do we? That's all I can see.
No, it's just a matter of logic.
Just a matter of logic, yeah.
And my Lord Kitchen, I missed the other stumbling block which I'm facing.
But you didn't actually rely on the resolution in any way.
In fact, strictly on Turquin, on Turquin and the way that I don't need to. I can just assume that the internal procedures have been effected.
You don't have to rely. Well, what about Freeman and Lockyer? Where does that come in?
My lady, I'm talking. What I'm saying. This is entirely for the purpose of whether or not. What I'm saying here is that I don't need to. I have been answering a different point. The point I have been answering here is that under Turquin, having been handed over the transfer, it is no good. It is no good for the company to say this transfer was executed without improperly or irregularly. I say, but strictly on Turquin, because of the non-declaration of interest. I say, well, that doesn't. Strictly on Turquin, it doesn't matter, because knowing that the company EACL has capacity, I'm repeating myself, then you can infer that it has been done procedurally correctly. That was the point I was answering, my lady. Yeah. The representation, the Freeman and Lockyer point, which I have dealt with before in relation to ostensible authority. We were handed over the stock transfer form. It's obvious, and you saw that Mr. Colombo has executed that. So there's clear what the reliance is. I know that we have had issues about what the representation was and who made the representation. But that is That is what we say about that. Just if I may have a little time, if I may just make some responses. That's all I wish to say, I think, at the moment in relation to Turkey, unless you have any further questions for me on that. Mr. Howard, in setting the scene when he opened his case, said there were disagreements between Mr. Watabi on the one hand, the Watabi camp, and Mr. Jones and Mr. Harter. And he said the reason why the transfer was dealt with on a Sunday is that Mr. Jones and Mr. Harter are in danger of being removed imminently. Well, as the court will know, there's no evidence or any suggestion whatsoever, there's no evidence or suggestion that P.T. Satria or Mr. Ciudadano knew of either of those matters. It's not suggested, there's no evidence that he knew of the warring factions within EACL. The urgency...
There was a citation of his evidence by the Court of Appeal to which Lord Reid drew attention, in which he referred to the requisitions. One.
I'm afraid, my lady, I don't...
Paragraph 132E and F on page 98.
I'm grateful, my lord.
I hope I didn't mislead you. Again, we've got Mr. Sahardno's evidence. There's no reason why it could be done urgently. And then that is a quote from Mr. Hatter.
I'm so sorry, it is.
Mr. Hatter explaining, basically...
That's quite right. Thank you.
So that's Mr. Hatter says no evidence whatsoever that there was any collusion here with P.T. Satria or with Mr. Ciudadano. That's why we keep saying, because there's no finding or evidence to the contrary, that P.T. Satria were innocent third parties. And the urgency, in relation to the urgency, Bundle 1, page 100, Court of Appeal judgment.
Sorry, just on that, paragraph 132E, and isn't there commentary there by the Court of Appeal, not directly referring to Mr. Suhardono's evidence, but by inference, that although he said he gave a particular reason why the negotiation happened so quickly, that actually was not to be accepted. See the last sentence.
What he's saying is, may I just read it in context? The HOA is premised on the assumption that the parties intended to negotiate final agreement. It was executed on the 27th of February. Mr. Ciudadano said in his statement that this negotiation did not occur because of the urgency of BEL's financial situation, and that it was never intended that the core terms would be renegotiated, and in consequence, on the 1st of March, P.T. Satria acquired the shares via a certified share transfer agreement. The notices convening the meeting were given on the 28th. On that basis, P.T. Satria must have taken the view that within 24 hours of executing the HOA on a Friday, BEL's financial position had worsened to such an extent that the board meeting of EACL approving the HOA and BEL approving the transfer must take place by Sunday, the 1st of March. This is incredible. So he's saying that...
Sorry, yeah, you go on.
What he's... Sorry,
Well, it seemed to me that was a commentary by the Court of Appeal about P.T. Satria's evidence and Mr. Suhardono's evidence, saying it's incredible.
What he's there not referring with respect. What he's... sorry.
I don't think
what he's in... I'm sorry, Lord.
Well, one might also read it with G on the next page. I mean, it rather looks as though the Court of Appeal wasn't accusing Mr. or let alone making a finding of collusion on the part of Mr. Ciudadano, but it was rejecting the explanation which he gave in evidence for the urgency and concluding at G that the circumstances that the thing was all being done in such a rushed way was an extraordinary fact which put PTS on inquiry.
Yes, well, of course, in relation to this matter at E, which is, these are matters which the appellant relied on. You see that from page 96 of paragraph 132. The matters upon which the appellant relies to defeat the claim, to rely on a sensible authority, can be summarised as follows. That's what they relied on as E. And what did the court find at 136, last sentence? If, however, the test is whether PT Satria was put on inquiry, I'd accept that they were, the reasons set out, other than the points contained in subparagraphs E and F. And in relation to, and what the judge says also at 135, what the sorry, could I take you to 134 on page 100? You'll see at the start of the line 53 in square brackets. I do not regard it as apparent from the material before us that Mr. Suhardono had such suspicion. The fact that Jones and Harter were personally guaranteeing that the necessary approvals had taken place was unusual, but also consistent with the guarantee being right. Further, Mr. Suhardono explained later in his cross-examination that the urgency was not PT Satria's urgency, but in order not to let BEL's licence be terminated by Pertamina. Now, unlike the incredibility which was said to exist in relation to the evidence referred to in letter E on page 98, there's no challenge, no suggestion that that wasn't honest evidence given by Mr. Suhardono. And in 135, care must also be taken in examining the question in the light of events after the HOA was signed. Whether PT Satria can rely on apparent authority is to be judged at the moment when the contract was made, even if the right analysis is that the agreement to transfer only became complete when the actual transfer took place on March the 1st, 2015. It is not apparent that PT Satria or Mr. Suhardono knew of the board meeting fixed for the 4th of March, or the intention to remove Jones and Hart as directors, or that, so far as PT Satria was concerned, the rush to transfer was to avoid their removal. Mr. Suhardono's evidence was that he was unaware of the intended meeting. So, as far as the Court of Appeal finding or accepting, PT Satria were entirely innocent third parties. And that's what
Thank you.
Sorry, I just see whether I need to make this next point, which I'm proposing to make. There was during the course of Mr. Howard's submissions an exchange with my Lady Arden. Mr. Howard said that at the board meeting of the 1st of March 2015, he said that the board meeting of the 1st of March was inquorate because of the failure to declare an interest, so there's no effective ratification resolution. And my Lady Arden said that is a position vis-à-vis EACL. And Mr. Howard said that was the position vis-à-vis EACL and everyone else. That's essentially the substance of his submission. And he said, and Mr. Howard said, or I took my note of what he said, was that ratification is an entirely internal matter. And I think my Lord Sales was attracted possibly by that. So the rule in Turkmen doesn't come into it. That was a note I have of Mr. Howard's submissions. In answer to that, we say, like, as with Lady Arden, at best, the ratification being irregularly resolved upon is ineffective only vis-à-vis the company EACL, but the position is different vis-à-vis third parties. As we know, ratification, or this apparent ratification, is by a resolution. And why treat this sort of resolution any different from any other resolution? May I posit this? The company could purport, or could pass a resolution, purportedly pass a resolution in advance approving the transaction, and the transaction could then be effected. In relation, when the company, that is the principal, says, but that's prior approval to that transaction, was irregularly obtained because somebody hadn't declared their interest. In that case, of course, I think everybody, or most people in this court, would accept that the innocent third party would be entitled to rely on the rule in Turquin's case. If that's right, and I submit to my lords and my ladies that it is clearly right, why should the same position not obtain in relation to an adoption of that act after the event? What is so different about the, quotes, ratification resolution? Turquin should apply equally to a prior approval resolution as it does to an after the event approval and adoption. And if Turquin does apply equally to both sorts of resolution, then in our case, the resolution is not ineffective vis-à-vis the third party. Mr. Howard did say that during the course of his submissions, no representation was made by EACL and no reliance by PT Satria. There was no reliance by PT Satria on any such representation. He said, and he took my lords and my lady to the evidence, Mr. Sordano, that Mr. Sordano trusted Mr. Jones. He overlooked the fact, as we made clear in our case, that we say the holding out by EACL was by the directors of EACL, two of whom actively participated in the transaction, and the third, by his conduct, also made the representation, leaving it to the others, permitting the others to get on with the business of managing the affairs of the company and dealing with its assets. Where's the particular bit? And my lords will recall and my lords will recall, my lords and my lady will recall Freeman and Lockyer, same thing Freeman and Lockyer at Lord Diplock, at Bundle 7, Tab 1, page 1936, in the middle of the page, the commonest form of representation by a principal creating an apparent authority of an agent is by conduct, namely by permitting the agent to act in the management or conduct of the company's or of the principal's business. And that is what Mr. Yamura did. He played no part whatsoever in the affairs of EACL. And that is a finding which the Court of Appeal accepted from first instance and is in the agreed statement of facts and issues. So that is, and Mr. Howard was suggesting that the representation, if there was one, was simply Mr. Jones holding himself up. In fact, that's not our case. Our case is he was held out by EACL to the knowledge of AOL. So we... and of course, just to go back, of course, we knew because the Court of Appeal relied so much on the due diligence carried out by PT Satria when it was entering into the negotiations. And I have been through already what that says, and that is relied on for having put them on inquiry. But when they were put on inquiry, what is it they would have found? And that is, put on inquiry is simply a shorthand for saying, put on an inquiry, and had they made the inquiries, this is what they would have found. But that's why I'm asking this court to say, well, let's accept they were put on inquiry. They were put on inquiry. They were in the sense that they had the articles, the bylaws, and they should therefore have looked at the articles and seen what they would have disclosed. And they would have disclosed exactly that which we say, that 2 out of 3 directors could bind this company at a validly convened board meeting at which the quorum is 2, and at which in any event, even if all 3 directors turned up, 2 out of 3 would win the day. And that's what I've taken, my lords and my lady, to that in my opening. Now, Mr. Suadano's evidence was that he trusted Mr. Jones. He'd dealt with him before. And what we submit to my lords and my lady is that the existence of that trust does not, in our view, undermine, it doesn't negate a representation having been made by EACL or reliance on it. What it does, what Mr. Suadano's evidence was, that trust had been built up over a period, particularly when he had dealt with Mr. Jones, when he made when he had his first negotiations in 2011 and 2012. And that's clear if one looks at Mr. Suadano's cross-examination. And I'll give my lords and my lady a reference. It's bundle 2 at 641 to 647. He's saying there why he did not deal with other directors, because he trusted Mr. Jones. Doesn't go to reliance on the representation, nor does it rebut or underline it. Submit. I was going to come back to the question which my Lady Arden put to Mr. Howard as to what does a director of a company do when the company is insolvent and can't get a quorum board meeting. I think that was put it to my friend Mr. Howard. That's a summary of the notes we took on our side of this court. And my Lord Sales said, having regard to the level of insolvency, my Lord might now remember this, having regard to the level of insolvency of EACL, the duties of the board became owed to creditors. Now, my Lord came back on that point, and my Lord expressed himself in a slightly more expanded way this morning, because in a manner which we say is correct, that the duties of the directors, if without more, would be, without any other factor, would always be owed to the company, even if it's insolvent. Even if it's insolvent. What happens when the company becomes insolvent is that the interest, that in considering the interests of the company, the interests of creditors displace those of the interests of members. So the primary focus for the board when the company is insolvent is to have regard to the interests of creditors. And that's, my lords and my lady will know from Kinsella and West Merseyside, who were in Dodden cases such as that. What we say is that when considering the interests of EACL, it is correct, because Section 97(1)(a) of the 1981 Act tells us so, that the directors were under a duty to act honestly and in good faith, with a view to the best interests of the company. In our respectful submission, be the directors looking primarily to the interests of its creditors or its members, that duty involved the directors preserving as best they could the assets of EACL. That is, the value of which was essentially BEL, and the value of BEL. The directors of EACL, knowing that its only asset were the shares in BEL, must therefore have been determined to protect the business of BEL, protect BEL, thereby preserving as best they could the value of BEL, which could only be for the benefit of EACL. That is how their duties had to be observed. Now, we know that EACL was clearly insolvent on the evidence before the court, I submit. Commercial insolvency, the ability to pay your debts as they fall due, or as it's now put, an ability to pay debts, is sufficient. And so, if that's right, that EACL was commercially insolvent, and we know it had to make a cash call which had gone unanswered. But in those circumstances, the board of EACL should do what they could best do to preserve the value of its assets for the benefit of its creditors. And it did have creditors. It had at least the Bermuda fee, which was payable, at least. Now, we can dismiss that and say, well, $2,500 doesn't matter very much. But the fact of the matter, it was a liability which had to be paid. It was a liability in respect of which, and there was also a reference to the company secretary, the corporate secretary, you'll perhaps recall that as well, which was referred to in the Court of Appeal judgment. Going back to my Lady Arden's question that she put to Mr. Howard, well, what would the board do? You've got liabilities to be paid, and you've got no income coming from your asset, BEL. In fact, you've got an asset which the license for the operation of which is severely under pressure and may be removed. The asset may be the license may be terminated. In which case, BEL will have no value whatsoever. So no ability to pay anything from below up to EACL. And so EACL said, we've got these liabilities, we'll make a cash call. And what happened in that case? They went unanswered. So I ask rhetorically, I think my Lady Arden didn't ask it rhetorically, perhaps, but what should directors do of EACL in those circumstances? And what they did in those circumstances, they entered into the HOA, which provided for the payment of liabilities of BEL as well as EACL. And pursuant to the terms of which, there was a prospect of income coming in when the plant was developed. But without those liabilities of BEL being paid, no doubt the employees would have walked away, the license was under threat, it was likely to be struck off, and it was a worthless asset. What the directors of the ACL did was to try to turn that asset to account. And it was only by turning that asset to account, we know on the evidence, that the creditors of EACL could be paid. Because there's no suggestion, in fact the evidence is, and it's common ground, EACL had no assets other than the shares in BEL. BEL, on this hypothesis, was worthless because the license was under threat. We've seen the financial statements. It was likely to be struck off. The two licenses were the license to develop the plant.
The point my friend made was just now saying that the creditors of EACL were paid off. There's no evidence of that whatsoever.
They didn't say that.
Sorry, I'm trying to finish my... what I'm looking at is paying off the credit. What the directors of EACL need to do is to pay the creditors of the ACL. Generally, a company has to pay its creditors. A legal obligation. How is it going to realise the funds to enable it to do so? It can either do it by realising some money from looking to its assets to give it the money, the wherewithal, by distribution of a dividend. But BEL was not in a position to do so. Or it could have gone to its shareholder and said, put us in funds to enable us to do this, to enable us to pay, albeit, as my friend says, to pay he would say, very insubstantial liabilities. But there was nothing. AOL turned its back on EACL. There was they went unanswered, and that's common ground. So what, and I come back to my Lady Hodgson's question, which was, if I may say, important, what are the directors expected to do? What should they do in those circumstances? And what I say they should do is seek to turn EAC's assets to account as best they can, so as to realise funds for the payment and discharge of EACL's liabilities. And that's exactly what they did. So what they did, sorry, what I say is this, what I say is what they did was entirely consistent with the obligations which they had. As I say, if as I said, if they didn't satisfy, if they didn't pay or provide or reach an agreement for the payment of the BEL's creditors, BEL would have collapsed in any event. That's everything else I want to deal with.
Does it follow that the figures as to the valuation of the asset of £60 million should be taken with a pinch of salt, because there were a number of creditors who could put the company BEL into liquidation?
Indeed, my lady. That valuation, there was no expert valuation before the court. I think that might be common ground. It was Mr. Harter, rather than a pinch of salt, my lady, I'd say a boulder of salt. There was no evidence.
Just on that, I think even in the audited accounts of BEL, admittedly for an earlier period, the asset value was given as 25 million.
Yes, and I took my lord, of course, to those accounts, which were signed off in 2010. Yeah. And I took my lord to the fact that the whole of that value was attributable to the value of the plant, which hadn't been developed.
No, but PwC thought that they could sign off accounts, you called it a hope value before, on a legitimate commercial view. It seemed to be something quite valuable. And
my lord also remembers that they called into question that whether, without the support, have you got this? Without the support of the... can we just go to... Mr. Gillian, just to turn up that PwC. But they did say, without the support from associated companies and shareholder...
Yes, certainly. I mean, money was ultimately going to have to be put into the investment to realise whatever the value one was putting on, the hope value one was putting on the investment.
Your Lordship's absolutely right, but what they were saying that we've prepared these accounts on a going concern basis, or we've audited these accounts. They're on the going concern basis, but we have severe reservations about whether or not that is appropriate. And the reason is because, in fact, it was under pressure. Can I just, my lords, it's bundle 5, my lords and my lady, it's bundle 5, it's page 4, I'm looking at page 1424.
Yes, all right. In fact, that isn't the document I had in mind. I thought we were shown as an annex to something else. The balance sheet.
Sorry, what sort of you show me?
Well, I'm sorry. You make your point. I can
Lord, I'm grateful.
Yes, 1401, thank you, Mr. Howard, is the document that I had in mind.
Yes, the balance sheet. Yes, what I had done when I was opening my case, as my lords and my lady will recall, I looked at total liabilities and shareholders' equity, 25 million. I looked at the 11.8 million of accumulated losses. And what I also said is, let's go up to, I invited my lords and ladies' attention to non-current assets, and that power plants under development, which can be the only plant, was valued at 25 million. You take that out, then you've got nothing. And then ongoing concern, my point is at page 1424. As at the 31st of December 2008, the company has a negative working capital of 8.3 million, accumulated deficit of 11.9 million, recurring losses and negative operating cash flows. Furthermore, the project is suspended as a result in a delay in obtaining permit from the government. These conditions raise substantial doubt about the company's ability to continue as a going concern, since ultimate realisation of the company's assets depends on the successful development of its commercial production and continuing financial support of its affiliated companies or its shareholders. Management believes that the company will continue as a going concern and has taken the following actions. It's in the process of negotiation with strategic investors to develop the project. B, continue to approach the government to issue the necessary permits. Shareholders of the company commit to support financially the operations of the company. Well, we know that's not the case, at least not in 2015. The shareholders of EACL have not committed to providing the finance. The accompanying financial statements do not include the effect of any adjustments that may be required if the company cannot continue as a going concern. That's what I had in mind, my lord. That's all. And Mr. Suadano's evidence, in fact...
We're running rather short of time. If you can just give us the references, we can read them for ourselves.
I'm grateful. Well, I'm going to invite my lords and my ladies' attention to Bundle 2. Mr. Suadano's witness statement, paragraph 13 on page 563. And I'm going to, the first two sentences, the first, paragraph 13 as a whole, thank you.
Yes.
And my lords, and my lord, my friend took you to PEC, which is in bundle 8, tab 25, and I'm hoping this, my lord, is going to be my last point. At page 2656, the bit I want to go to is paragraph 73. You can read it to yourselves, but I would refer you particularly to the 4th to 8th line. If this is proved, it does not matter in English law that her belief was unreasonable, so long as it was not dishonest or irrational. So that is one of the authorities relied on by my learned friend. He took you to Mr. Justice Andrew Smith, but Mr. Justice Andrew Smith was there following Akai. My lords, unless I can assist your lordships and my lady any further, and I'm grateful for your patience, I will close my case.
Thank you very much, Mr. Todd. Well, this appeal raises a number of interesting questions, and we're grateful to both counsel and indeed of all counsel for their assistance. We'll take time to consider what advice we will humbly tender to Her Majesty.